Professional indemnity insurance is an essential buy for any medical practitioner in Malaysia. But how do you choose the right medical professional indemnity insurance? Here are 4 critical pointers to look out for. You never know when your past negligence will catch up with you. It's critical that you choose an insurance coverage that provides you with unlimited retroactive cover. When you retire from your profession, it's highly impractical to keep paying for your insurance policies every year just to protect yourself from the past years of practice. Therefore, it's critical that your insurer offers you run-off cover that protects you from historic liabilities post your retirement. In the event of a claim, there may be conflicting interests between you and the insurers. It's very critical that the lawyer representing you truly protects you. Choose an insurer who allows the choice. In the event of a significant claim, you would want an insurer who can respond in a timely manner to your requirements. Hence, choose an insurer who has the capacity to pay your claims without having to consult other insurers who may be jointly insuring you. We have made your life easier by factoring these 4 critical factors, along with many other doctor-friendly features, to offer you the best medical professional indemnity insurance at DoctorShield. Our policies are underwritten by Chubb, the world's largest publicly traded property and casualty insurer. DoctorShield is a convenient way to buy customized medical professional indemnity insurance at competitive premiums. Visit thedoctorshield.com to future-proof your medical practice.
Hello, everyone, and welcome to what is our last medical legal webinar for this CBD cycle, which ends on the 30th of June. But fear not, we will continue with the new cycle starting next month. We are now having these webinars at the last week of every month. The SGMC grand rounds are usually on the first week of every month. So we have 2 webinars every month, and that's 2 CPD points. If you stick with us every month, then in 10 months, you should get your 20-point quota quite easily. Please I just want to remind you that you can still claim points for all our webinars for this current CPD cycle, which is from 1st of July last year until 4 days more, 30th of June. You can still watch our webinars and claim CPD points right until the 30th of June. And after that, we'll have to move on to the next CPD cycle. Instructions for how to claim points after watching, even though these webinars are no longer live, are in the pinned comment of each video. Essentially, you have to declare that you've watched, then you message me what video you've watched, and we'll scan in your points for you. So it's as easy as that. All right, so today's medical legal webinar, as arranged by our friends, DoctorShield, is on medical report and record preparation. Why is it crucial? And the presentation is by Puan Fazliza binti Asli, advocate and solicitor, partner at Chan Van Eng and Co. Okay, her talk is roughly, I think, about 30 minutes, and it's a pre-recorded talk, which I'll stream in a little while, and then that will be followed by Q&A. Just some basic housekeeping. If you can, please join us on Slido at 3948885, or scan this QR code in your QR code scanner to visit slido.com at that exact location. You can put your Q&A there, or else you can ask in the YouTube chat. Okay. As the little video clip was displayed earlier, please do subscribe to our channel so that we can keep you updated of our upcoming live streams. And CPD points for dentists, we've already displayed this in our webpage. This link is for you to pre-register and claim points. dobbs.my/dentist0624. For the doctors, I'll display the link. Medical doctors, the link will be displayed after the talk and the Q&A. All right. So without further ado, let's move on to the lecture itself. And okay, and I'm going to remove myself from the stream, and after that, I'll start the video.
Hi, good evening, everyone. Thank you for joining the session. My name is Fasliza, and I'm currently practicing at CBE, Chan Ban Eng and Company. The topic of my presentation today is on medical report, medical record preparation. Why is it crucial? And I'll try to make it short in terms of the presentation, as I'll be focusing more during the Q&A session. So let's begin our presentation today by looking at the provision of the governing legislation when it comes to the medical report and also medical record. And there are two. One is under the Private Healthcare Facilities and Services Private Hospital and Other Private Healthcare Facilities Regulation 2006. Hereinafter, I'll be referring to as regulation. And the next one, it would be on the Malaysian Medical Council MMC Guideline on the Medical Records and Medical Report MMC Guideline 002/2006. Hereinafter, I'll be referring to the MMC Guideline. Okay, now, what is medical record? Medical record is documented information about the health of an identifiable individual recorded by a practitioner or other healthcare professional, either personally or at his or her instructions. It should contain sufficient information to identify the patient, support the diagnosis based on history, physical examination, and investigations to justify the professional management given, record the cause and result thereof, and ensure the continuity of care provided by practitioners and the other healthcare workers to that particular patient. Medical records were historically regarded as aid memoirs for physician treating patient and as essential component to patient care. They contain information about the patient on one part and the physician's opinion and clinical judgment which brought to bear on the patient's management on the other part. So now, what does the medical record contains of? On this aspect, we are referring to the sixth schedule of the regulation, where it clearly clear in the sixth schedule, where it says that each patient medical record shall contain the following: A, the registration number, the patient's name, address, date of birth, and gender, the name and contact details of a relative or friend or legal guardian, the relevant clinical details of the patient, which includes the clinical history on admission, progress notes during stay at the healthcare facilities or services, medication orders signed by a registered medical practitioner, known allergies and drug sensitivities, current medication, pre-operative or pre-procedure assessment, and result of any relevant diagnostic tests. However, in a situation where a special procedure, operation, or anesthetic is required, the following information should be part of the medical record. First is on the consent form, on the date of the operation or procedure. Thirdly, on the names and the signatures of any attending medical or dental practitioner carrying out any operation or procedure, type of operation or procedure carried out, pre-operative or pre-procedure checklist, administered drugs and dosages, record of any monitoring data, record of any intravenous fluids, bloods, and blood product, operation or procedure room report, final diagnosis of the patient, any notes or remarks concerning outcome of any operation, and the anesthetist complication, if any. So that is the provision in the regulation. However, in the MMC guideline, the following to form part of the patient's medical record, which is the doctor's clinical notes, recording of discussions, referral notes, laboratory and histopathological report, imaging record, clinical photograph, drug prescriptions, nurse's report, consent form, operation notes, video recording, printout from monitoring equipment, letters, computerized electronic record, recording or telephone consultation. So, how do we prepare a complete medical record? Under Regulation 44 of the Private Healthcare Act, it is provided that all entries in a patient medical record shall be dated and authenticated by the person who gave the order, provided the care or performed the observation, examination, assessment, treatment, or other service to which the entry pertains, and legibility returned in ink, typewritten, or recorded on a computer terminal, which is designed to receive such information, and if recorded and stored in a computer, it may be stored on magnetic tapes, disks, or other devices suited to the storage of the data. All original copies of any patient's medical report received from any other healthcare facilities or service shall be filed in the patient's medical record in the private healthcare facilities or services. Whereas under the MMC guideline, in order to prepare to prepare a good medical record, first of all, the use of the integrated clinical notes. The use of integrated clinical notes is encouraged. This means that the medical practitioner, the nursing staff, the physiotherapist and occupational therapist, dietitian, and any other person involved in the management of the patient will all make contemporaneous entries on the same continuation sheet in the medical record. This would enable each and every member of the management team, i.e. the doctor, the nurse, the physiotherapist, the dietitian, etc., to keep direct track of the daily management procedures of a patient without having to refer to other records in the folder. The entry in the continuation sheet should be precise and legible and record the date, time, and the procedure or treatment in chronological sequence and should be signed by the person making the entry. The name of the person should be clearly written below the signature or the name rubber stamp so that the person making the entry can be traced later without difficulty if such nuts arises. If all this is more for the court purposes, that in the event that we need to determine who made the entry, and then it would be convenient for us as lawyers to track which witnesses and all that to testify in court on behalf of the doctor in medical negligence cases. Things to be avoided in preparation of the medical record, first of all, is on the use of abbreviation and also short forms. Abbreviation and short forms should generally be avoided when making entries in the clinical notes and continuation sheet. The use of unfamiliar or unconventional abbreviation and short form may lead to untoward incidents in the management of patient. In this particular aspect, I would like to share my personal experience in dealing one of the matter before the court, where it involved care management pertaining to a patient which is in the ICU. So apart from arguing on the causation, whether there's negligence or otherwise, the other aspect where the patient's expert picked up is on the abbreviation. It is more in terms of the dosage of the medication given to the patient in the ICU, because according to that patient expert, this particular abbreviation is not known of. And at the end of the day, he could not comment whether the dosage given to the patient is actually in the order. So with that, we just need to submit before the court, and there's an expert basically to comment on this particular abbreviation, whether it is acceptable or not acceptable, or at the end of the day, it is actually a well-known abbreviation. So at times we think that it is not material, but when matters being litigated in court, it do make a difference to begin with, especially when it comes to dosage of medication in ICU, whatever, that is really important. All right. Apart from that, the things that need to be avoided to be included as part of the medical record, it would be those entries which is not relevant to the management of the patient. It is imperative that the practitioner and also the nursing staff or an ancillary staff should avoid entering irrelevant, disparaging, derogatory, or offensive personal remark about the patient or other colleagues and healthcare workers in the patient's clinic notes. Practitioners and the nursing and the ancillary staff should avoid leaving blank spaces in between entries in the continuation sheet so that no person may be able to make late or retrospective notes in such space. Such entries will probably not be in chronological sequence and may be interpreted as false as an attempt to cover up errors. In fact, in this aspect also, I would like to share my personal opinion where I attended a matter in which we have been instructed to defend an ophthalmologist. So in this particular case, like the main issue is whether the referral for the patient to undergo CT scan was done in a timely manner. And according to this particular ophthalmologist, yes, he has advised the patient to undergo CT scan because this is actually in view of the accident and apparently he suspected foreign body in the eye. And according to that particular ophthalmologist, he did advise, but at the end of the day, the patient refused for some reason. So when we submitted before the court and upon perusing the medical record, the strange thing is that every time there's an entry on the referral to do CT scan, it is always towards the end of the medical record, the last page of that particular day, or the last entry on that day, in which there's no notes in between. It is not only like the first entry, but the subsequent entries, the same thing appears. So under that circumstances, it casts a doubt before the judge whether at the end of the day that particular entry is genuine. Why is it so coincidence that it's always like towards the end of the notes for the day instead of sometime in between the notes and etc. So this is something that doctors should take into consideration as well. Apart from that, on the correction of notes, erasure or blacking out of entries already made in the continuation sheet should be avoided. If there are reason for some corrections, the erroneous statement should be neatly crossed out but still be readable. The correction should then be entered in space available next to the deleted statement and signed clearly by the person making the correction. The tampering of clinical notes should be avoided, and this may be interpreted as a member of the management team making alterations to cover up some mistakes in the management of the patient. Now, the next thing is on the confidentiality of the medical records. Under the MMC guideline, medical records are to be classified confidential for administrative purposes within a healthcare facility, and it is acceptable to label the medical record on the cover not to be handled by the patient. Whereas under the Regulation 46 of the Private Healthcare Act, it is highlighted that nothing in this part shall be construed so as to waive the responsibility of a private healthcare facility or service of custodian of a patient's medical record to maintain confidentiality of such record in its possession. On the security and safekeeping of the medical record, under the MMC guideline, it is stated that the responsibility is actually towards the person in charge, and the medical record must be stored in a safe and secure room at all times when not in use. They must be protected from the weather and vermin. They must be easily accessible and retrievable when required and returned in the complete form after use. As a general rule, medical record must not be taken out of the healthcare facilities. Whereas under the regulation of the Private Healthcare Act, it is actually the responsibility of the licensee or person in charge to make sure that the medical record is kept and maintained in the patient's medical record register to record the movement of the patient's medical record. Now, on the ownership of the medical record, under the regulation, it is actually belongs to the private healthcare facilities or services. Whereas under the MMC guideline, it is stated that the property of the medical practitioner and the healthcare facility services holds all rights associated with the ownership. It is important to appreciate the confidential nature of the medical record, and though the practitioner and the healthcare facilities and services have right of ownership, they should still obtain consent from the patient or next of kin before any release of information from the medical record to any third person. So consent is required before that medical record to be released to a third party. Now, on the issue of medical report. Medical report are documents prepared by a practitioner on the patient based on medical record. And the contents of the medical record as provided for under the MMC guideline, that it should be a brief statement of who the practitioner is and his specialty and appointment, whether the practitioner has the authority to write the report, a statement of which medical record were available when writing the report and any special circumstances. The medical report may contain in whole or part the following: patient's identification data, dates and time, brief history, significant examination, result, diagnosis, treatment, and also management plan. At the end of the day, when the doctor prepares a medical report, it must be tandem with the medical record. Whatever information is not there in the medical record, by right, it should not be reflected in the medical report, because medical report and medical record, at the end of the day, it should work hand in hand, and it must be tandem in terms of both documentation. There should not be extra information provided in the medical report where it cannot be obtained in the medical record. If that things happen, at the end of the day, it will cast a doubt, as to why this particular medical report is so comprehensive when certain information is not there in the medical record to begin with. Okay, now, the importance of the medical record and report preparation. Firstly, on the legal status. Medical record, while not strictly classified legal documents, it may be considered legally supportive documents in a court hearing. Whereas under the MMC guideline, medical report like medical record can be demanded and produced as legally supportive document. The court has the right to call the practitioner who generated the medical report to appear before the presiding judge or magistrate to explain or clarify the content of such report as may be required. Okay. In medical negligence cases, it is a settled law that at the end of the day, we are relying on volume test. What is volume test? Volume test is that we defer to an expert opinion, basically, like to state whether there's a one-off care or otherwise, to enable an expert to prepare a medical report. At the end of the day, it is actually based what has been stated in the medical record. If the medical record is not comprehensive enough, there will be a difficulty for the expert that we engage to prepare a complete report before the court to determine whether the matter is defensible or otherwise. So that's the reason why it is really important, the entry of the medical record, it should be comprehensive, and it's not just a very skimpy entry and whatnot, because with that, at the end of the day, the expert, they are not able to render their full and frank opinion, because we are not supposed to provide additional information to the expert which is not reflected in the medical record. And in the event the expert were to accept additional information besides the medical report, at the end of the day, when they testify in court, their credibility will be questioned as well. So more often than not, it is something that the expert is not keen to do at the end of the day. Okay. On the patient's right to medical report, in terms of the law, it is pretty clear. There's a provision in the MMC as well as the provision of the regulation as well. But there's a court action on this particular matter where we are referring to Nurul Husna Muhammad Hafiz case, where it is pretty clear where the court has decided that there's no requirement in law that the patient first obtain a court order to get access to his medical record. Meaning it is actually as of right for the patient to request the medical record from the health facilities. And Regulation 44 sub 2 does not deal with the patient's right of access to medical record. And based on the guideline as well, it seems that the patient have a right of access to their medical record. And in the event that the medical record are withheld unreasonably, then the patient is put to cost to procure that particular report. At the end of the day, the court will be penalizing the healthcare facilities in withholding the medical record and not to release it to the patient. Okay. In terms of the timeline to provide a medical report based on the MMC is about 6 weeks. And in the event that the practitioner are not able to meet the 6-week period, they should be conveying the reason as to why it cannot be released within time. And under the MMC guideline also, it is clearly stated that the refusal of the consultant to provide medical report, it is actually unethical And at the end of the day, it is subject to the inquiry proceedings before the medical council. And of course, in preparing the medical report, the practitioners are able to ask for a fee, and the fee must be reasonable and must be duly communicated to the patient. That's all on the presentation, and I shall to the floor for question and answer session. Thank you.
Well, thank you very much for the presentation, Wan Fazliza. And we will now go on to the Q&A session. We'll wait for Wan Fazliza to come online. Okay. Hi, Puan Fazliza, your mic is muted. Nice to see you.
Hi.
Thank you very
Hi,
much
Dr.
for the nice presentation, and you have the privilege of being the final medical legal webinar for our CPD cycle. So which ends on 30th of June. We have one question in Slido, so we will maybe deal with that first. The question is, using computerized system, there's no signature use. I think this is maybe also, I don't know whether uh, he means the records or particular sections like consent forms and so on. But I think maybe I can just mention this in the electronic medical records. I think when we enter, it is actually documented who is entering already. So that's like an electronic signature. What about consent forms? Are they required to be hard copy or electronic? Because we also need the signature from the witness and the patient also. So I think whereas the electronic records will only capture who is entering, unless there's an electronic way to capture the signature of the patient and the witness. What are your
Yep.
comments about consent forms?
Yeah, basically on the consent form, I know that for most of the hospital, they are not really comfortable by merely, like e-consent form. Or sometimes at most of the hospital, they say that at the very least, there must be like e-signature. Or they tend to have like two versions. One is the hard copy and the other one is the electronic consent form. So my advice on that aspect is that at the end of the day, even with the physical consent form, if the patient were to seek issues, they can always seek issues. More often than not, when we appeared in court, consent is one of the issues that we need to address. And most of the time, the patient's argument is that I don't know what is it all about. Nothing being advised. It's just that the doctor said you sign here, or even the nurses who are assisting at the clinic say that you sign here. So I merely sign. And at the end of the day, that they are saying that if I don't sign, basically there's no procedure can be attended to. So at the end of the day, the most crucial part is that there's some sort of advice on the risk of certain procedures. And if that can be reflected in the medical record, that would be good enough. Like for those computerized system, because I handle a matter where it involves electronic medical record, there must be someone who is familiar in the system, should be able to address the court how the system works. Those days, we used to call the hospital CEO or those person in charge, for example, to explain. But now the trend, it seems that the hospital are more keen towards calling someone from the IT department, for example, to address how the system works. Because my understanding is that, for computerized system, there's always an icon for each and every entry. So in terms of the prescription of medication, for example, if you just click one icon, there's only one medication. So in order for you to take note what other medications, so there's a few like icon need to be clicked, then the whole thing would be out. And basically someone should be able to explain to the court how does the system works. At times as well, the patient's lawyer, they just tend to argue as to why certain documentation are computerized, certain documentation are not computerized. Is there any difference? So what are the difference? Why is it different standard? So someone should be able to address and to convince the court that this is the practice. Yeah. So that's the issue. It's not so much of the consent, because at the end of the day, why we require the signature is just to make sure that the patient is aware of the risk of that particular surgery. So since they are aware of the risk, therefore they decided to proceed with the procedure. As I said, even with the consent being taken properly signed in a hard copy, if patient tends to seek issues, they can always seek issues. So that would be my answer to that lah. Yeah.
I have actually a personal question related to consent and recording. One of the common repeated procedures is blood transfusion. And some patients, like those with thalassemia, they're getting blood transfusions like almost every month or quite regularly. And how can one consent form be used to cover a long period of time rather than take individual consent forms every time they have a blood transfusion? What is the legal point?
Okay, I believe the prudent approach is that each and every time when the patient attended for blood transfusion, then there must be like a different consent form, because that particular consent form, it is only for that particular procedure specifically on that particular date. So at the end of the day, in terms of the risk, yeah, we still need to explain and that kind of thing, because like I do come across cases where there's a wrongful blood transfusion. At the end of the day, there's no side effect, like gotten by the patient, but it's just that she's not happy, wrong type was given and that kind of thing. And of course, like in terms of the damages, it's pretty minimal, like it's about 5,000 and 10,000. So it's just that, like one consent form, it cannot covers let's say like for 1 year. So each and every procedure, it should apply to one consent form, because like usually there'll
What
be
if
a
the
date.
consent form, or what if the consent form states that this is valid for blood transfusions from this period to this period?
But I mean,
In practice, some of these patients are going to have folders this thick full of consent form for blood transfusion. It's
right.
actually become quite a nightmare to store all these things,
Right. But at the end of the day, the reasonable period, I believe it would be maximum 3 months lah. So every 3 months, there must be like some sort of renewal, just to remind them again that this is your consent form. At the end of the day, this is of the risk and that kind of thing. If not, they're gonna tend to argue that, okay, I only signed one consent form, then that's about it. There's no further advice on risk or whatever things like, yeah.
There's a question in Slido. Before we go on to, there are quite a lot of questions in YouTube. But if a doctor forgot to record an event and only notice and then write a retrospective entry during the inquiry meeting, the case notes, is this acceptable?
During the inquiry meeting?
He writes a retrospective entry.
Oh, okay.
I
mean, yeah, I mean, it all depends in terms of duration, because my understanding is that when it comes to inquiry, for example, it is when, like patient lodge a complaint, or in the event that patient pass away, then of course that there'll be like some sort of inquiry. So if there's a lapse of time, let's say like 3 months down the road, what makes you can recall this particular incident? So are you trying to cover yourself just because of the inquiry meeting? Therefore, you decided to, like log in or need to make a retrospective entry on this particular incident, for example. And it all depends as well in terms of what we call that, the whether that particular entry is really important or otherwise, like, if it's just not so important, so it doesn't really matter. But usually in terms of late entry, it would be something which is pretty crucial, that make a difference in terms of the outcome of certain things lah. So if at all, yes, it can be done. And in the event that further questions being asked, there must be like some sort of clear explanation as to why. Because it would always like cast a doubt, even for lawyers or judges. Oh, why is it like after 3 months you can recall about this? If you say like after 3 days, then it's still reasonable. Like 3 months, like for us sometimes like we don't even can recall what we did for the past 1 week. So what triggers you? Something like that. Yeah.
So it's okay if it's just pending to it as a afterthought, but just to clarify.
Yeah, just to clarify. Yes.
Okay. One more question. Can consent be written on the patient's card instead of using a separate consent form? I presume he means in the notes.
In the notes, okay, my usually in terms of consent form, I believe it's a pretty standard form. I know that for some of the hospital, there'll be one standard consent form. I know that, for example, for those consultants, let's say neurosurgeon, I attended one matter. Apart from having the standard consent form provided by the hospital, this particular neurosurgeon created his own consent form. Because he's of the view that there's a lot of things that to be addressed, and in order to cover himself as well. So it can be done because, as I said, consent, it is more for the purposes of explaining to the patient that this is the risk that I've already explained to you. And at the end of the day, you understand the risk, and therefore we would like you to sign. So it's either in terms of the witnesses, it can be like your family members, or at the end of the day, it can be the nurses, for example. If you were to call the nurses to be the witness, the argument is that, well, the nurses is together with the doctor. At the end of the day, whatever things that she, testify in court is going to be leaning towards the doctor to protect the doctor's interests. Like if you were to say, okay, how about your family members? Then the argument going to be, well, actually, there's no explanation. It's just that, the nurses doctor asked myself and my husband, for example, to sign. As I said, if they would tend to find fault, to seek issues, there's always a room for them to do so. So there's no hard and fast rule. It all depends. Let's say if you are working in a particular hospital, they do have their own guidelines. If you're operating your own clinic, then of course, as long as there's an SOP in place, and in the event that there's an issue, then of course, we can always address the court. This is the SOP of the clinic. We have been complying with this. And at times the court will want to know, is it something in return, or is just like oral, basically everyone knows that this is the practice by way of mouth. So someone should be able to establish that before the court at the end of the day.
So it's better always to be separate consent.
Yes, better to be separate. Yeah.
I just have a question also on the release of medical record. You mentioned in one of your slides that is under the MMC guidance, the patient has a right to request and the practitioner should not withhold release of information. It's quite common. We see patients who say on regular follow-up in government hospitals and they request their lab reports or x-ray reports, and then they're told we cannot release. What are your comments?
Well, actually, that is a wrong approach, because my understanding is that it's not so much for teaching hospital. I mean, there's one hospital. I cannot say that they are government, I suppose. So their approach when it comes to the X-ray or even like lab report, that is not considered part of the medical record. So if you would like to request for this documentation, there's a separate documents to that effect. And they say that this is our internal practice. So we explain to the patient's lawyer that this is the internal practice of that particular hospital. And so far, they have not come back to us to say that this is not acceptable. But frankly speaking, based on my experience and based on my presentation earlier, it should covers all that as well, meaning that the X-ray, the lab report, everything, that is actually inclusive of the medical record. That's what a complete medical record is. Because, for example, if we were to engage an expert, we need to provide the entire medical record. Sometimes like the expert will write into us, apart from the x-ray report, perhaps they wanted to view the film. That one I can understand. Yeah, they can always print out. But if we, in terms of the blood gas investigation or some sort of readings is not there, then like basically the expert, they cannot form an opinion. They cannot provide us with a complete opinion because the information provided in the medical record is not complete. And like at times when it comes to disclosure, we say, okay, this is the thing, I'm going to give you this. And after reviewing the papers and whatever, then the patient decided to sue. So when the patient decided to sue, so we thought that that's the final medical record. Then the hospital would give us, like bits and pieces of information. I think we need to include this as well. So why was it not given at the initial stage? It's just that they realize that since there's a suit, they need to defend. So this information is important. So at times we need to explain to the court why. Because at the end of the day, when the patient receives the medical record, they seek opinion. So it's actually based on that particular documentation. And if there's additional documents, then the expert is need to review the documents back. Maybe the opinion will be different, that kind of thing. So that's the reason why to us, at the end of the day, practicing in medical negligence, like defunding the consultants and also the hospital, yes, that should be inclusive. And I'm sure at times, even for the consultants, they say, if Aziza, I remember that this particular prescription, but it's not here medical record, that's important for me to define my case. Then we'll be writing to the hospital's lawyer to say, hey, where's this? Then check with the hospital. Oh, we thought it's not relevant. Then we will ask for them to disclose at the end of the day.
Okay, there's a series of questions in YouTube which are quite related. One is how to balance the need for comprehensive documentation with the risk of information overload. And then the second question is also similar, how to ensure accuracy in the face of very high patient volumes. Do you have any comments? I mean, basically, this is the day-to-day dilemma we doctors face.
Yeah.
I mean, there's a lot to document. At the same time, you're pressured. We got so many patients. I mean, it's actually only humanly possible to do so much.
Yep. Sad to say that, at the end of the day, time constraint, high patient volumes, it is not acceptable. I mean, it's not an acceptable explanation or reasoning to the court. I mean, there's one matter where we presented that one particular consultant and basically he did, I mean, he's just telling the truth, like there's not a patient, I need to explain or whatever. Then the court did not take it in a good way. So the court is of the view that that particular surgeon is arrogant. Because at the end of the day, I don't care how many patients you have, you earn your fees from the patient. It should be both ways communication. So by saying that, you have no time or whatever, that is no longer acceptable at the end of the day. And, like in Singapore, in terms of the advice on risk, it has been codified. So, like whatever it is, like this is the law, you need to follow. It's just that sooner or later, I believe it would applicable in Malaysia as well. So once it's codified, there's more excuses that I can't do this because time constraint, that kind of thing. If you decided not to do that, then of course, like if there's a medical legal suit, then you need to face the consequences. You cannot just say that, oh, at the end of the day, I did explain this is my practice. Yeah, you can mention that verbally. But if you were to communicate that to the expert, sometimes, like they cannot accept that because like at the end of the day, it would somehow affect their reputation. How can I rely on your words when the thing is not there? So the plaintiff experts and the doctor's expert or the hospital expert should be looking into the same documentation. There should not be any additional information supplied to the doctor's expert, the hospital experts. Everyone should be looking into the same documentation. It cannot be some sort of extra. Then only it can be what we call that a fair report in order to determine whether there's negligence or otherwise. I know it's very hectic, time constraint, but as the matter stand, that's how, the practice now, there's nothing much that we can do about things.
Yeah, either don't see more than you can handle, I guess. The other thing,
Yeah.
I think one of the
Mm.
previous speakers said is actually record everything. I mean,
Yes, correct.
you know, uh,
Yeah.
maybe it'll come to that eventually where everything has to be digitally recorded, audio, maybe even visual, and then
Yeah.
archived somewhere.
Yes.
And then it can be referenced. But then you
Yep.
do document the essential points. But I think
Mm.
sometimes we have to think about and if we are just saying we are too busy, that means maybe we are not prioritizing the right thing, I think.
Mm.
Uh, yeah.
True.
There's a so this same thing. I mean, how to keep up to date, real time, and fast paced. So I think maybe computerized records and digitalizing certain things may improve efficiency. This one also is a bit related. How do you address discrepancies and consistency in patient records when multiple healthcare providers are involved? So maybe one person records something, another person records another thing. Like somebody
Yep.
says he's got allergy, another says he's got no allergy. So there is
Yep. Well, at the end of the day, in that circumstance, lah, so we will be calling those who make the entry to appear before the court and for them to explain. So that's where, like if that particular entry is not in our favor, we tend to do cross-examination. So it is more for the judge to observe whether this particular witness is a truthful witness or otherwise. Like if it's not, somehow he knows, like, or based on the questions that we ask, why some they just tend to admit that, oh, there's a typo error. Then of course, like we need to show like certain documentation. It cannot be like conveniently, like to say that there's typo error but without any basis. For example, like on that particular matter which we represented the ophthalmologist, like based on the report, it clearly shows that the vision is back to normal after 3 years of the surgery. Then conveniently, like during the trial, it's just that this treating doctor from the government hospital said, you know what, actually is a typo here. And of course, like we do raise objection on what basis that you are saying typo. You just come to court and say that there's a typo error without showing us the actual documents. Is based on what? Because like the incident happened about 10 years ago. So if at all, there must be like some sort of explanation. And in the event that whatever discrepancies, if we are of the view that it is not in favor of the hospital or the doctor which we are representing, then we will call up the maker to explain. Like it can be an honest discrepancy, or sometimes like this discrepancy is really important. Like, it would determine whether there's any delay, whether in terms of the medication given is in order, whether the nurses do really take note of the doctor's order, or basically they don't really care. So all this is really important lah, because at the end of the day, it is a team effort. It's not like I'm consultant, so it's me, you hospital, so it's different. It's always a team effort. So our main thing is actually to defend the claim against the patient. It's not so much that it's just me, not the hospital, and that kind of thing.
Maybe I can chip in one thing from my experience when my hospital we moved from paper to electronic records, and this is one area where electronics records can help with inconsistency because you can have common dashboards, say your past
Mm.
history, medical, your social history, family history, all are common. They're not in different sections written by different people, so you can see, and then you can amend, and then amendment is also recorded. Somebody said,
Yep.
"Oh, no allergy," and I amend. I said, "Yes, there is an allergy, so and so
Mm.
document." And then
Mm.
a nurse can also amend that and pick up,
Yes.
"Oh, this patient's on this particular method." So actually, we can all see in a common way, and this
Yep.
actually reduce errors in inconsistent recording. And
Mm.
also, it's easier to search through all your colleagues' documentation. So maybe as we move forward to electronic medical record, it will help. There's a lot of pain also. Some people just they're frustrated with documenting. They type slowly and things like that. But
Yep.
I think we will have to adapt. Yeah.
Yeah. I mean, like we're
There's a
moving towards
question.
that, like, of the day.
Yeah. What are the legal implications if the records become inaccessible, say computer failure, hard disk failure, destroyed? Who is responsible? I have also a
Then
low tech, a very low tech equivalent of that. Some rural hospitals in Malaysia, they give the records to the patient to take and keep. they don't store it. So the
Right.
patient carries the records with them. And then, of course, it could be destroyed in some banjir or something like that. So who's
Yep.
responsible at the end of the day?
Because at the end of the day, I mean, there must be a good explanation. Like for medical negligence cases, the duration, what we call it, the Limitation Act, it is actually for 6 years lah. So usually we advise that maybe you can keep it for 7 years, then after that you can dispose it off. And yeah, let's say like if there's no medical record, for example, it's gonna be difficult for parties to defend, and it's gonna be difficult for the patient as well at the end of the day to basically substantiate their claim to say that this is medical negligence, because they need expert too. So there must be like, I mean, that's the issue, like who to be blamed then, because at the end of the day it is under the hospital's care. Like of course everyone will look towards the hospital, and in the event that like it's destroyed by malware or ransomware or whatever, that's where, like, when I give my presentation to the hospital, they are trying to improve in terms of the security, the IT. So that's the reason why they will ask their IT personnel to attend, so that they can understand the gravity. Why is it important to make sure that the system is in order, so that they can understand? If not, by the CEO or whatever just telling, like they couldn't know what's the effect of it. So by attending to the medical legal, like presentation, whatever, at least they know. Then like they will try to resolve the issues, to see that backup system, whatever, how like they can work towards it, like to make things proper and etc.
Yeah, I think any system worth its salt would have
Yeah.
backups outside
Yeah.
the hospital, and I think
Yeah.
that's a more IT problem. This is an interesting question. There's the color of the pen matter in documentation. Must it be legal black? Can we write in blue, for
Yeah, I
instance?
mean, it can be in black, it can be in blue, but sometimes if we are of the view that there's a retrospective entry, that's where the lawyers would want to have sight of the original medical record. So from there, we can roughly know whether it's a new entry or it's an old entry, like the ophthalmologist case, which I mentioned earlier. Sometimes like we can see the difference of the ink, or at times they
Mm.
will send it for the forensic handwriting expert to confirm. Like some people, they will just go to the extent. In terms of the color, it's not an issue, but sometimes like we can determine whether it's a fresh entry, or it's just like recently, or it can be like a few years back. Yep.
Yeah. So I think this is pertaining to manual handwritten records.
Yeah.
So the thing is, don't try to amend, don't try to change it, but add in as an amendment. I think in our electronic medical record, there will always be a computer trail of what
Yeah. Like it's
amendment
easier,
we've done.
like you can
So
trace,
that yeah, yeah.
sign in, sign off, what
Uh,
time, all that. Yeah.
yes. Are we allowed to underline documentation to highlight important clinical information?
Yes, it can be done. It's not an issue. Yes.
Mm,
Mm.
okay. Can the patient be allowed to get a copy of his or her signed consent if the patient asks for full medical record without a court order or lawyer's letter? Can we release?
Yes, in terms of the signed consent, yes, you can provide a copy to the patient, because at the end of the day, I don't think there's any harm, lah, because you've already advised accordingly, everything is there, and the patient did sign. And in fact, once a copy has been given, perhaps there should be some sort of notation that patient requested for it, and the hospital or the consultant or whoever the nurses release that particular form to the patient. On the full medical record without court order, as per what I highlighted earlier during my presentation, that the case law is very clear. If the request, it is actually from the patient, yes, we need to disclose the same without any court order or even without any lawyer's letter. In the event that the patient passed away, usually we want to know who is the next of kin, the legal representative. So with that, we will always request either the grant of probate or letters of administration. Yeah, we don't accept, like basically for the husband to come and say that I'm the husband, so I would want So we would demand like some sort of legal proof that you are the legal representative. It doesn't mean that, like your husband, so it's as of right for you to obtain the medical record.
I think the informed consent one is actually quite commonly done because the informed consent contains a lot of information. Say it's informed consent for chemotherapy, and then just
Yeah.
explanation what are the adverse effects. Well, I think it's a good idea for the patient to have a copy so they can
Correct.
actually. Sometimes we
Yeah.
explain it's difficult for them to grasp in one sitting. They go back and they can read again and
Right.
understand their procedure, be
Yeah.
it chemo, surgery, or whatever. I think it's a detailed consent form. It's educational for the patient. It's
Yeah.
not just the
Sometimes,
legal part.
like they will request because you will want to consider, with that, like perhaps within 24 hours. I mean, it cannot be more than 1 week, something like that. Because to us, the reasonable period is either within 7 to 14 days.
Yeah, yeah.
Mm.
Okay. There are some other things in the YouTube. If you can glance on the YouTube comments, Ms. Lisa, is there any you want to highlight? Because some are more like not quite questions, they're more like comments, I think. Um, mm, I don't quite understand this one from Farah. During court hearings, reports may lack important or supporting clinical findings actually affect the outcome of case, example for DV, stroke, physical injuries. Mm, what is DV? Do you? Yeah, not sure what she means. If the report lacks important clinical findings, mm, maybe we'll skip that.
Like for example, okay, let's say in terms of physical injuries lah, if we are of the view
Mm,
that rehab is required or future care management is required. So apart from getting an expert opinion on liability, whether that's negligence or otherwise, we would always send patient for assessment. Like with this, usually the consultant and the hospital, we will be engaging a joint expert. So you are saying that you're having this, but in order to be sure, we will want you to be our expert to assess you. Like, is it true that you're having these physical injuries? And in view of that, like for example, you cannot stand for long, and because of that, it affects your earnings, like for example, yeah, that kind of thing. Or in terms of the nerve injury, for example, in view of that, you cannot continue your profession as an engineer. So under that circumstance, usually we will send the patient for second
mm,
opinion on rehab, on future
okay.
needs. So I don't think at the end of the day, the issue of justice would arise, because when it comes to that, like we will, like send for assessment to get a second opinion. Then we will
Mm,
compare,
mm,
this is our expert assessment, and at the end of the day, this is a plaintiff assessment. So which one is more reasonable, and we will
okay.
submit before the court.
Mm. DV stands for apparently for domestic violence. Yeah.
Or domestic
Okay.
violence.
Domestic violence. Yeah. All right. I think some of them are more like comments, and I think some also like Dr. Ho says, "Thank you for the clear and concise presentation, simple and very precise facts." I think we like your presentations, Fasilia, clear and to the point. I think a lot of
Thank
us.
you. Thank you very
Yeah.
much.
So yeah. We are almost at 1 hour already, so I think I'll have to move on to the final bit, which is the how to claim CPD points. Let me share this tab. So for the dentist, you already pre-submitted your registration and attendance under the top form. For the medical doctors, this is the attendance form. Please, you can go on, open your browser, go to dobbs.my/260624, or you scan this QR code and it'll take you to the form to fill in your attendance. You can't scan this QR code with the MMA app, please, because the MMA has disabled the QR code scanning for attendance online. This is just a QR code to take you to this same link, dobbs.my/26064. It's a form. You fill in your details and we will upload to the MMA. This link will expire on the 27th. That means by midnight. So you have until midnight. But after midnight, until the 30th of June, you will be able to still claim points. Just read the pinned comment in the YouTube video, all right, for the instructions. So after 30th of June, we will start a new CPD cycle, yeah, and we will uh, have new sessions on for medical legal again. There are some interesting ones upcoming. So thank you all for watching. Another grateful attendee, Liwa. Thank you for your comments. Okay. So thanks, Farah, for watching, and all of you. We will, and most of all, Puan Fasliza, thank you for your very good insight into this topic. And
Thank you
I
for
think it
having
will
me as well.
strive. Yeah, yeah, we should strive all to better documentation and better record keeping. I think that's very, very important. Uh, Even in my hospital, so every time we go through, we are in the hospital uh, HMS committee, often we see lack of documentation, even where we are supposed to comply, not just with the law, but with organizations like JCI. We will fail
Mm,
if we don't do this and that. Yeah,
mm.
so it's a challenge. Okay.
Yeah.
All right. So I bid everyone a good night, and I wish you all well, and we'll see you in the next webinar. So thank you once again. I'm going to end the stream now, and I hope everyone has a good week ahead. Okay. Good night.
Bye.
Okay. I think it went well.